Okay, it's your turn now. We've been talking at you for 45 minutes, an hour, and so we've got time left. We advised the panel 10 minutes each. Think what if we'd have said 15 minutes each, you know? Anyway, it's your turn. We're going to take questions from the audience, and then we're going to take a question from the audience in the webinar, and then we're going to alternate until we run out of time. We have a microphone right there. If you would, go to the microphone, state your name and affiliation so that people on the web will know who you are. We'll start with this question, and then we'll go to one from the web.
I'm Jutta Hennig from Inside U.S. Trade. Question for Craig Thorne and for Mr. Bilchik. The U.S. government made some vague, more or less vague effort to try to offset the impact of the EU-Korea agreement on GIs. What is the status, and are you satisfied with the efforts that have been made on seeking to prevent the undermining of trade concessions? And for Mr. Bilchik, could you give us a sense of how receptive your clients might be to this notion of not taking back these, what the U.S. producers call common names of components of GIs?
Okay, Craig. Okay, regarding Korea, it's true. You don't miss much, Jutta, so I'm not surprised that you noticed what went on in Korea. When we saw the first draft of the EU-Korea agreement, we realized that it included an annex with a long list of names that would be protected automatically with entry into force of the agreement. And a lot of those geographical indications corresponded to names that we consider to be common names. And so we raised this with the U.S. government, and they approached the Korean government. You remember at that time, the U.S. agreement had been negotiated but hadn't entered into force. And we basically told USTR that we have an impairment problem here. We have concessions that have just dropped in value potentially if this agreement is implemented in the wrong way. So they approached the Korean government, and they got some assurances from the Korean government, mainly on this issue of scope of protection. What it means to protect Parmigiano Reggiano, what it means to protect, I don't know, Camembert de Normandie, Brie de Meaux, and so for the compound geographical indications, they gave us assurances that we think give us some legal certainty. I don't think we'll have any problem marketing our products in Korea. And Korea is a big cheese export market, so this is a serious commercial concern. We still have some potential problems, some likely problems, with respect to the single-term GIs, like Feta, Asiago, and a couple of others. And we're not sure how we're going to deal with that issue. That's what we're afraid of, is seeing that same problem replicate itself around the world.
But isn't your real problem with the common name not, so I'm at a loss then, what is it you're still looking for? There's no assurance that you can use these component names?
No, we do have assurances with regard to the compound GIs that we can, for example, we're not worried about their ability to continue to sell U.S. origin Parmesan in Korea. And we never did have the ambition to sell U.S. origin Parmigiano Reggiano cheese. So the problems that we have is with the problems are with the single name GIs, and I'm not sure how we're going to deal with those in the long run.
Okay, maybe Uda, you and Craig could get together after this. It's a technical matter. We have lots of other people who want to participate. David, would you have a brief response?
Yes, I don't know. But there are people here who probably could tell you something afterwards. Okay, thank you. Sorry.
Okay, do we have a question from the web?
Are there any valid estimates of what the actual cost would be to rebrand the names defended by the Coalition of Common Food Names?
Craig?
Single brands, total cost, or?
The questioner just said what the actual cost would be to rebrand. Sorry.
You know, I have seen in the past estimates of the cost of rebranding a product, a single product, and it's substantial. But I'm really bad with figures that I don't have written down in front of me, so I'm not even going to try to tell you what the figure is. I'd be happy to get it to you later. But the important thing is to talk about, you're talking about tens of thousands of dollars, hundreds of thousands of dollars. I really can't even remember the scale. And we're talking about hundreds and thousands of brands that are produced domestically and exported around the world.
Okay, very good. Yes.
Hi, my name is Vicki, and I'm from the Department of Commerce, and I'm helping out with dairy and food security for the TIPP. I have a kind of a two-part question, one for the biotech side and one for the GI side. Matt and Sue, actually I missed your presentation, Sue, sorry. So if you had covered this, I'm sorry. You had mentioned that 22 approvals have occurred in EU. Have you experienced marketing restrictions? I mean, why aren't the 22 approvals, I guess, more accepted? I mean, or can you just tell us about more additional barriers?
Actually, the issue is there are 22 that are pending decisions that they have completed a scientific review process in Europe. They're just awaiting a decision by the Commission. So there is not an approval for those products. So I was talking about the pipeline of products that are currently awaiting approval. In terms of the products that are already, I don't have the number of the products that are already approved in Europe, but primarily you see, as JB was saying earlier, I mean, one of our top exports is soy and soy meal. Corn exports have not rebounded after some trade disruption issues several years ago, but soy and soy meal, the products that are have been commercialized for those products are, we are able to get it into the European market.
So there are no marketing restrictions for those products, for soy right now?
Well, there
Is that
are
right?
criteria that you have to, regulations in terms of, labeling requirements, et cetera. But those aren't, those we're not making a concern in terms of the TTIP. I think the soy industry is probably better to answer with respect to any specific marketing restrictions on products. But primarily the products are going in there for animal feed. And I'm not aware of any major disruption for those products that have been already approved.
Okay, and if I could be just a little bit more greedy, the GIs, I think you mentioned that you asked a company to desist from using the Parma style name.
Yes.
What law did you use? Do you know? Do you remember?
Yes, but I'm not, not, my lawyer wrote a wonderful letter, and their lawyer replied saying, okay, but as you know, I'm not a lawyer. Let me just elaborate just for a second. There are many, sorry, Craig, there are many companies in the United States who would like to use Parma on their ham. They've done it in the past. This was the most recent case brought to my attention. Over the last, since 1990, we have consistently used our lawyers, talked to people and said, please don't. It's an infringement of our intellectual property rights. It's confusing to the American consumer. Please don't. And most people have stopped. Including this current example. Why do they want to use our name on the so-called, but we don't, prosciutto, as you say, Craig, is ham. Parma prosciutto is something else. And we don't want the American consumer to be confused. So the law is really, it's more common sense, good business, and also maybe a little bit of fear, I'm sorry to say this, that this ugly consortium in Parma, Italy is going to go to court, which we have done and which we can do. Not all producers of these wonderful geographic indication products have the resources to do what we do. That's a shame. And I wish the law were a lot simpler here so we could, as you all suggest, register the names and live happily together. but that, you know, the lawyers are making a lot of money on all this stuff, and so it's not simple.
Okay. Mary, do we have a question from the web?
Yes. Can anyone highlight some of the progress that was made in last week's first round of TIPP talks?
Okay, who was close to that? Who would like to respond?
I'd give a really short answer to
Okay,
that.
very short, Greg.
I don't think that there was any progress made, especially on the issue of geographical indication. I think it's fair to say that that first round was pretty much organizational. They didn't get into a lot of detail on issues like GMOs or GIs.
Okay, back to the audience.
Okay. Don Phillips, American Sugar Alliance. Sue, you indicated that you would favor a separate bilateral discussion on GIs. Do you or other panelists think that's realistic given the importance of the EU? I mean, is this going to be kept out of the mainstream TIP negotiation?
I'm going to defer that question down to Craig because he's a lot closer to the dynamics within the actual negotiations. I think it's important to address the issue, make it very clear what the common food names are that we can continue to use. But Craig, I'd invite you to answer the rest of the question.
Okay. I think that the goal of U.S. negotiators has been to keep the discussion separate. And I think that makes sense because as far as we're concerned, we think there's actually a potential for an agreement that could benefit both sides, but it has to be self-balancing. Which means both sides need to get something of interest. What we, of course, are anxious to avoid is a situation where GIs traded off against another issue. But whether this issue is discussed within the negotiation or separately, I think the only way forward is for the Europeans to reset their goals so they're more realistic and they take into account our interests, and for us to be willing to also to address some of their concerns.
Thank you.
Thanks, Don. Mary?
I have no more.
Okay, Ralph?
Thank you. Ralph Fischer, I'm the representative for French wine and French dairy industry here in the US. First of all, a little note on history. I mean, everybody seems to believe that the GI and the protection of GI dates back to the EU. It's way older than that. I mean, the first treaty between the US and France for the protection of cognac, Tennessee whiskey, bourbon, et cetera, was signed in the 60s under the Kennedy administration by Foster Dulles. I have the document to prove it. So, you know, there is a history of protecting each other's geographical indication, whether you call it geographical indication or certification mark, whatever. I tend to agree with Craig that in 98% of the cases, we shouldn't have any, or maybe even 99% of the names, we shouldn't have a problem. Let me give you a counterexample of what we see as the abuse or the excess of the trademark legislation. A few years ago, I had a producer of Chambol Musigny, red Burgundy wine, who sold a few hundred cases of wine, very high priced in the US. His name was André. One day, his importer in Chicago got a nice letter, or a nasty letter, from the Gallo's lawyers, a cease and desist letter from Gallo saying, Champagne André is our trade name, you infringing our intellectual property rights, cease and desist. Now, I mean, and eventually what happened is that the importer didn't want to pick up a fight with Gallo because he was a small guy. The producer had no money to pay for the lawyers, so he gave up. So my question is it right? I mean, is a bottle of red Chambol Musigny with his name on the label? Because after all, it's his name. His name was Mr. André. Can't he put his name on the label? Is this right to keep him out just because Gallo sells something which is called Champagne André or California Champagne André, which we contest, by the way? So, you know, we feel that the trademark system is not a perfect system at all. I mean, and we have also issues with certification mark and the way they use the name protected in the certification mark in other trade names and so on and so forth. we feel PTO sometimes is a little lax in accepting these legislation. Thank you.
No question there, but would you like to respond?
Well, I'll just say that I don't feel under any obligation to defend the U.S. trademark system. I know that there's some problems with the U.S. trademark system. Maybe not the one that you were talking about, because I don't know the details of the case, but I'm familiar with some of the complaints that Europeans have had regarding the nature of the collective mark registration system and the difficulty of registering collective marks. So I just want to reemphasize that for us, it's an issue of access to common names.
Hi,
Okay, we have a question here.
Hi, my name's Janelle Pepe, and I'm with CF Industries. My question is on timing. Since you've kind of been in some of these negotiations, is this something that you see as a very long, drawn-out process? Do you think it is possible to get an agreement done during this administration? Kind of just your thoughts on timing.
Okay.
Our Canadian negotiations have missed every deadline, and deadline and deadline and deadline. So it's been, you know, and we're not, and we're a much simpler, we're a much smaller fish.
Matthew?
I would only say, I can't imagine that this negotiation will meet the fate of the Doha round negotiations, because you are dealing with two very willing parties. So it surprised me to hear myself saying this, because there's no way I would have thought this was possible 15 years ago. But I do think that there will be an agreement, that getting an agreement between the two sides is possible, but it's going to take longer than 18 months.
Matthew?
But don't you think the real issue is we can get it?
Yeah, the people on the web can't hear you, so please, go to the microphone.
Can I just add something that I think if the rush is for the deadline, then it will be a much smaller agreement, and then the real question is if they really want to stick to the Obama term deadline, the Commission deadline 2014, I think is completely unrealistic. Then the real question becomes what can be accomplished in that time. Everything that's on the table cannot be accomplished in the timelines that they have now.
No, I agree. And one of the things that the U.S. agricultural community has been very clear about from the start is that the agreement needs to be a single undertaking, that all of the important issues need to be considered at the same time. If that's the way the negotiation proceeds, and I believe that's the way it will proceed, then it's going to have to take a while, because the issues are complicated. It's not going to be easy to find solutions.
Okay, Mary, do we have one from the web?
Well, I think Mr. Thorne may have answered this already, but it's a follow-up to the other question. Would a potential bilateral GI discussion be in tandem with or need to be done well ahead of the final deal? You just addressed it.
I think we've addressed that. So.
Ryan Beery, Washington correspondent, Europolitics. Just for Mr. O'Mara on GMOs, what do you think the TTIP negotiations are going to focus on the GMOs issues? Because I was a little surprised that your position was sort of like you don't particularly want the EU to change its legislation, you're fine with the labeling requirements, so then what is there really to talk about?
Well, I think that the issue here is that the underlying legislation, if it worked, if it was implemented predictably and consistently, we would not have a major backlog of products sitting awaiting approval. So I think what the negotiations are going to have to focus on is how to, we can't predetermine what it's going to look like. I think what we need is a discussion on how to practically address the backlog. Are there ways within the current system to kind of address certain, it's as simple as getting a vote sometimes. I mean, sometimes the votes get canceled. I mean, are there ways that just logistically we can address kind of the process? And so I think what we need is a discussion just to sit down and figure out how to kind of make the trains run on time. Because if they run on time, we don't have an issue, per se. I mean, and although, we're not looking to overhaul any legislation, I think we still intend to be ambitious in the sense that we want there to, I think we do want to address LLP in a real way. I mean, LLP, I think it's significant if the U.S. and the EU could work out a way forward on LLP, because Europe is a major importer. U.S. is a major exporter. Frankly, I think it's maybe even a better discussion for a global, better for a global discussion. But I think if they could begin to kind of frame out how to address that in a way that is practical, I think it would be profound for biotech trade globally. So I think the ambition here is also to have an impact globally, not just a direct market impact in Europe.
Okay, we have one here. Could you come to the microphone? Thank you.
Thank you. I'm Giulio Menato, the Agriculture Counselor of the European Union. Just a brief and generic comments, if you may, as we are entering into negotiations, so please forgive me if I'm pretty generic in my comments. But I think it was worthwhile to say something. First, thank you for this event. It's again an opportunity to have more information and more detail, more concern from stakeholders. Such meetings and the presence of a so sophisticated, organized stakeholder from both sides has really a value added to these negotiations that can be addressed in a better and more practical way because of your comments, your presence, etc. So it's really a value added. This event has many others. We have clearly realized when consulting with the stakeholders. And really, I could say that also, I can imagine also from the U.S. government. Yes, the agreement needs to be comprehensive, is an issue. There are many issues on the table. The industry has clearly mentioned tariff. Absolutely, it's tariff that has to be tackled. Would be difficult issues, especially when tariffs are higher in areas like dairy. So any liberalization will be painful for producers. But we have to address that, that's for sure. You mentioned rules. Of course, we have to improve rules. So far, our preferential trade is based on multilateral concessions that we made in WTO. And our preferential access to the U.S. is still based on dairy, still based on the Kennedy round, with the rules of the Kennedy round. And so, although everybody loves President Kennedy, Kennedy is pretty outdated. So we really clearly an updating on rules on our preferential trade, and the agreement we provided that advantage. Certainly, there is a link on SPS. We have concern also from our sides, and now the right fora to discuss. Certainly, there is an issue on GIs, and the debate of today has presented these issues from both sides that have to be addressed. Again, the negotiations are comprehensive, ambitious, and have to address all these issues on the tables in order to reach that single undertaking that we are looking forward. So it's difficult to conceive parallel paths when you work on the edges of a comprehensive and single undertaking, ambitious agreement. And because all these issues are crucial for us, geographical indication have certainly a value on our agriculture. It's a value that is related to quality and what it is in traditions and territories, etc. What it is, would like also to underline that such a debate is a debate that has already taken place in many opportunities in Europe. We had a wide variety of countries, a wide varieties of opinions. And so certain conclusions have been really debated, intensively debated. You may have followed the Parmesan cases in Europe, the Feta cases in Europe, and we reached certain conclusion after very throughout debate on that in terms of why and how we have protected those products in Europe. Thank you for space.
Thank you. Okay, I think that gets us to our allotted time.